Attorney Pence, let me start with you. Thank you. I don't think the public understands the stress on the lawyers for both sides of the case. I also don't think the public appreciates the fact that without defense lawyers, there wouldn't be a prosecution. Because in our adversarial system, as much love as the state might get, the defense lawyers seem to get the opposite. Yet you step into those shoes, and in this case, I've seen very capable lawyers working very difficult facts, often without any appreciation. So to the extent that you and Mr. Hunt did a fine job, you ought to at least be publicly acknowledged. So thank you very much for a long career.
Thank you, Your Honor.
The first part of the hearing, when the victims were speaking, was what I expected. A built-up, raw emotion of rancor and ill will, and all very understandable and unfortunate. If anything cathartic can come out of today, it might be of the fact that there's some closure, or maybe not forgiveness, not forgetting, but the fact that the process will have worked and people can move on. Whether you choose to accept that or not is yours, as any free person can, but maybe closure helps. There was a reference to this being the worst massacre in the state of Ohio. Well, let's go with something else. To call this the Pike County Massacre, frankly, is condescending to the rest of the good people of Pike County. It's tragic, it's heinous, it's unexcusable, but it's not an indictment of the entire county. That's social media typecasting. The worst massacre in Ohio might very well be 1792 at Canada Hutton, when 96 Christian pacifists were killed by the Pennsylvania militia because they were Christian pacifists. But each generation has its own people who can prove the depths of depravity of human nature. And that's what this case did. It showed the boundless depravity of people who have no respect for others and their only self-interest in mind. And that's transgenerational. Since the dawn of man, this sort of depravity happens. So the raw emotion you communicated was expected is unfortunate, and I hope somehow you're able to get past it. Not forgetting, but getting above it. But good luck, because what I just asked isn't easy, as you well know. With regard to sentencing, however, the court's not bound by nor has any role in using emotion. The government's responsibility is not to use ill will. We don't have people being burned at the stake as in the medieval days. We don't have public shaming. We don't have a remedy that works. We have analytical guidelines that courts are supposed to follow in imposing sentence. It's not meant to be emotionally driven. So I wipe all the emotion and follow the sentencing factors. The first set of factors are whether the case is more serious or less serious. Clearly, it's a more serious offense for all the reasons stated in the statute. Whether recidivism is likely is the second set of factors. Well, there's a long sentence coming. And I'm supposed to predict the future, which I can't do. So recidivism prediction is virtually impossible. It's backward looking. So I'm just going to find that the risk factors for recidivism are balanced equally against the less likely, because I don't know what you're going to be as a person or who you'll be after your long prison sentence, Ms. Wagner. The fact that you completed 40 or 50 programs might bode well for you, and it might not. So I'm not going to try to predict anything with regard to the future. You need to understand that there's a mutually recommended sentence. If I impose the mutually recommended sentence, then any opportunity you might have to appeal the sentence is waived or given up. Generally, when a person enters a plea of guilty, they give up any rights to appeal the verdict of guilt. So presumably you don't have appeal rights as to your plea. If I impose the sentence today as recommended, then there's no appeal rights on that issue. The only thing that might be left, dare I say it, would be ineffective assistance of counsel, and I don't have any opinion on that. So if I impose a mutually recommended sentence, your appeal rights are waived as to the sentence. Do you understand that?
Yes, Your Honor.
And that's what's going to happen. I lined up the numbers differently than the lawyers recommended, but they come up to the mutually recommended 30 years. So for purposes of the record, with regards to count number 9, complicity to aggravated murder, I impose a 9-year prison sentence. On counts 10, 11, 12, and 13, I impose a 9-year prison sentence. That's an aggravated burglary. For unlawful possession of dangerous ordnance, count 14, the maximum 12 months in prison. For counts 15 and 17, tampering with evidence, 3 years in prison. Count 16, tampering with evidence, 3 years in prison. No sentence on forgery, no sentence on unauthorized use because they merge. On unlawful interception of the oral communication, 18 months in prison. And then for the obstructing justice in count 21, 12 months in prison. And then engaging in a pattern of corrupt activity, 9 years in prison. Mr. Crapence is right to remind me of the recent case of Beatty. I saw that come rolling out first week of December. Maybe that was in my entry 2 weeks ago with regard to having to follow the mandates. A lot of people might think judges have unlimited reign, if you will, to impose sentence when in fact we have pages and pages and volumes of rules and case authority on how to impose a sentence. So the Beatty case tells me that there's a mandatory duty with regard to the firearm specifications to impose the maximum 6 years consecutively to each other. So there's a firearm silencer specification that has to be imposed on count 9 and count 22. So there's 6 years plus 6 years is 12. With regard to 9 more years for the aggravated burglary charges, those run concurrently with each other, consecutive to the firearm specification. So we're at 6 plus 6 plus 9. And then finally on the corrupt activity charge, count 22, there's a 9-year sentence, which is consecutive to the 9. So now it's 6 plus 6 plus 9 plus 9. Is my math right, Mr. Crapence? 30 years. The other charges all run concurrently, so that felonies 3 and 4 don't add additional time. It's 30 years in prison as mutually recommended. You're entitled to 2,244 days credit over 6 years, 6 years and 6 weeks. So that comes off your sentence as a matter of law, because past time has to count. With regard to economic sanctions, there's no fine. Your inability to pay makes that impossible, not only in the past but in the future. There's a legal obligation to pay court costs, processing, booking, pay to stay, medical expenses. So all those numbers should be added up and put on your bill. Your ability to pay depends on future economic circumstances, but it's a legal obligation to impose. When you're released, you have to be on supervision with the adult parole authority for at least 2 years up to 5 years. While on post-release control, you have to follow rules, regulations, restrictions on your freedom. If you fail to comply, you can be sent back to prison for up to 50% of the longest term, so that would be 50% of one of the 9s. So the 30 can turn into 34 and a half for additional violations after you're released at the end of 30 years. You have a legal obligation to register as a violent offender. There's a database. So at the time of your release, you have an obligation for at least 10 years to register as a violent offender. Tell the sheriff in the county where you reside, where you live. If you fail to comply, that can be a parole violation, post-release control violation, or a separate felony 5 offense. And the legal duty can be extended if the state establishes just cause to extend it beyond the 10 years, which doesn't start running until you're released from prison. Did I overlook anything? Knappa? Mr. Craypens?
No, Your Honor, my client has signed an affidavit of agency from the clerk.
Thank you. Yes, that's. I'll hand this back to you. You can have the filing done. Further evidence, Ms. Wagner, of how thorough your lawyer is. See it? To the extent that I wasn't bound by the lawyers, I could have gone higher. I wasn't here when this started. The analysis is pretty true. The state needed you. And in fact, you came through with your part of the agreement. Does that matter? Well, morally, that's up to you. Legally, it's a big deal. In my journal entry, there's 2 cases cited that clearly explain the importance of cooperation, the benefits of mitigation. You help the state make the case. Jake helped the state make its case. That wisdom, wherever it came from, was the difference between a much worse outcome that might very well have been appropriate. I understand you didn't go to the 4 scenes. Nobody seems to talk about the fact that you're the only person that could have stopped the whole thing with 1 phone call. You're standing there with cell phones that people want you to ping to make it look like you're home. All you had to do was call in. Stop the whole thing. The depravity was that you didn't see the moral need to shut it all down. I don't need an explanation, but clearly any decent human being could have done that little bit to save so much. So with the fact that you accepted responsibility and cooperated, I was willing to follow the agreement. You'll see the Anderson case and the Rahab case is cited in the decision. They go back to 2017 cases. The Supreme Court made it really clear twice in the same term the importance in the system of having people accept responsibility and cooperate. So for you, that's the only silver lining. That concludes that case. Ms. Wagner, they're going to walk out the side door. Moving on. Thank you, Mr. Craypens. It's my pleasure to meet you.
Thank you, my pleasure.
Have a good day. Mr. Wagner, that allocution, that statement, further demonstrates the role the court does not serve.
I know.
Everything you just said is perfectly appropriate. It's been heard many times before, as has the victim. But to the extent that there's a religious overtone, I don't factor in religious values. It's the same standard. The legal prescriptions, the laws of the government that I imposed. I heard remorse. I heard your understanding and your explanation for it. But to the extent that you might, or somebody might have taken that as preaching, that's fine, except it has no meaning to me, except for remorse. If it was more than that, Mr. McVeigh helped me understand, but it just demonstrates that the same ill will and rancor that came from the victims, and understandably, the is now your faith experience on your side, neither of which is the role of the judge, the duty of the law. So it highlights what goes on in courtrooms on a regular basis.
Your Honor, what I might add to that, perhaps by way of further explanation, is that I believe from my conversations and conversations with my colleagues with Mr. Wagner, that the statement that he made there was, he wanted to speak to the victim's family, and rightfully so. But I don't believe that it was in any way intended to sway the opinion of this court when it comes to sentencing.
We said the same thing different ways.
We did.
I can't accept that.
We did.
For benefit of the record, a lot of the victims in the gallery walked out along the way as they're allowed to. So they don't have to hear what he chooses to say. It's how it works.
Yes, Your Honor.
In fact, this day is more intense than many, but it's all too familiar on the criminal court documents.
Yes, Your Honor.
With regard to sentencing, Mr. Wagner, the court has the same analysis. Severity factors, well, obviously, clearly, there's more serious factors. There are no less serious factors. With regard to whether you're likely to be a repeat offender or not, I'm not going to have a crystal ball to project where you are after a long prison sentence, so I'll just find that the recidivism factors balance out. It's unpredictable, but I did the analysis and thought about it. With regard to the penalties to impose, count 1, aggravated murder, life in prison. Count 2, aggravated murder, life in prison. Count 3, aggravated murder, life in prison. Count 4, aggravated murder, life in prison. 5, aggravated murder, life in prison. Count 6, aggravated murder, life in prison. Count 7, aggravated murder, life in prison. Count 8, aggravated murder, life in prison. Count 9, conspiracy to commit aggravated murder, maximum 11 years out of Department of Rehabilitation and Correction. Counts 10, 11, 12, 13, aggravated burglary, maximum terms of 11 years in prison. Count 14, possession of a dangerous ordinance, 3 years in prison. Counts 15 and 17, tampering with evidence, 3 years in prison. Counts 16 is tampering with evidence, 3 years in prison. Count 18 merges, so there's no sentence on 18. Count 19 merges, so there's no sentence on 19. Count 20, unlawful interception, 18 months in prison. Count 21, obstructing justice, 12 months in prison. Count 22, engaging in a pattern of corrupt activity, the maximum 11 years in prison. And then count 23, unlawful sexual conduct with a minor, a 4th degree felony because of more than 4 years of age difference. In that case, 18 months in prison, the maximum sentence. With regard to firearm specifications, the court's duty-bound under the recent Beatty case to impose mandatory 6 years on the first firearm spec taken from count 1 and 6 years on the firearm specification found in count 2. You're entitled to 2,244 days of jail time credit up through including today. You're required to register as a violent offender. You also have sex offender registration requirements. The sex offender registration requirements apply upon any release from prison, which would be for a period of 25 years, registering at least every 6 months with the sheriff in the county where you reside. And if you change your address, take into employment, then you have to change your registration anytime you change your variable. A violent offender database, as you heard earlier, is a 10-year registration, which can be extended. And if you fail to comply with the sex offender registration or the violent offender registration, that can be a violation of any terms of release or a separate felony at the time. The Chief Justice appoints retired assigned judges to work on cases where there's conflicts or problems. And I take that very seriously. It's a privilege after retirement to be granted the opportunity to come back and continue to help my colleagues. That's why I get out of bed every day. There's a need, there's a problem, maybe a skill to apply to resolve the need and the problem. That's how I got here. We talked about this with her dad months ago. I got two problems when I walked into this case. I'm going to explain the two problems. The first problem was a recommendation on your case that was the same as it was on your brother's, life without parole, which is what he got, right? How did he get there? He went to trial. He had 10 weeks of trial, and he had thousands of dollars and dozens of witnesses, and emotional energy and staff energy, people energy, resources energy to get him to his conviction. Yet the recommendation here is the same, giving you no credit for all the cooperation that you gave. As Mr. McKinney said, you don't have corroboration of a cooperative witness, you may not have any case. So I have to resolve the first problem is how is it that I'm supposed to treat you the same when in fact you didn't act the same? That's the first problem. The second problem is how do I resolve the good deal that your mom got? 30 years is a really long time. That's a really good deal for the level of the conduct, especially since she could have stopped the whole thing dead in its tracks before it ever happened. And I don't let her off the hook because she didn't go to the scene. I put her equally responsible because the eyes of the law put her equally responsible. So my second problem is how do I resolve what looks to me like some sort of gender violence? And here's how I resolve it. I give you the opportunity of parole after 20 years on your prison sentence. So you do 6 on the gun spec, you do 6 on the gun spec, you do life on all the other counts, everything concurrent, with the opportunity of parole at 20 years. So 32 years out, you get your chance because you cooperated, because you did something to acknowledge the responsibility for the crime. That's not a deal, but that's as close as I can come to solving the problem that's handed to me by these ancient plea agreements. If everybody wants the last judge's sentencing deal, they should have sentenced him under the last judge. Everybody knew Judge Deering was gone right after the last trial, but nobody rushed it in to get it, and when I show up, I solve the problems the way I'm supposed to. So you get your chance to talk to the parole board 32 years from now. And then they do their job, whatever it might be. So I'm not going to sign off on a deal where you get the same for cooperating as your brother does for going to trial. There's the explanation. Court costs, processing, booking, paid state medical expenses, have to pay as a legal obligation. There's no victim restitution because they have civil remedies available. So you can go ahead and be excused. We're going to register you under both those registries. And we're going to take a break. So we're going to go off the record. Thank you to the lawyers.
All right, and Ms. Villanelle? there, but I just will ask you and your attorneys to please stand while I'm imposing sentence. Typically, I would have you come forward, but I want you to be able to rely on the walk or the table if you need to, ma'am. So, and I just want to take this opportunity to remind everyone as well that no outbursts or emotional expressions will be tolerated. You'll be removed from the courtroom if that does happen. So to kind of reiterate, Ms. Gillen, you're here on the counts that your attorney stated. You've got the 1 count of assisting self-murder or manslaughter, 2 counts of aggravated assault with a firearm, and those refer to Mr. Jackson, the security officer, and Mr. Aponte, both of whom testified here today. And then you have that 4th count of aggravated assault on a law enforcement officer with a firearm. And there were 6 officers who were named as victims in count 4 of the indictment. So the score on the criminal punishment score sheet is 115 months, which would be 9 years, and roughly 8 months. The state, as you know, has agreed to waive the minimum guidelines and agreed to cap your punishment at 10 years prison. And I first want to talk about some of the testimony that I've heard today. And Ms. Gillen, I accept your testimony today that you've given with respect to the fact that Jerry was suicidal. I know there's no records that document that, but I accept what you stated, that he told you and continued to express that he was suicidal. I think that makes sense that a husband would confide in his wife of 53 years with respect to his serious emotional condition. I accept your testimony, ma'am, that his condition was worsening. Can you hear me okay?
Yes.
Okay. I accept your testimony that you and Jerry jointly decided to commit suicide, that you believe that was the only way out. And I accept your testimony that you do not remember staff informing you about comfort care or hospice. I think the doctor testified honestly with respect to what hospital procedure is, but I think it's highly likely that that either didn't happen or that you don't remember it. Also, I accept Dr. Danziger's testimony that you continue to not be a risk of danger to the community and that you were suffering from some sort of mental health episode on the date of the incident. I want to point out that, as everybody knows, this is not just a case about you and your terminally ill or very ill husband, because we've heard from the fact, from the testimony today, that there are many other victims in this case. And by entering your plea, you've admitted to having pointed a firearm at 2 hospital employees. You've admitted to having pointed a firearm at many Daytona Beach police officers as well. And we've heard today that there were 34 patients, 33 other patients on that floor who potentially had their treatment, their medical treatment disrupted, not to mention putting them in fear for their lives and perhaps their family as well. And then I don't even know how many hospital employees and their family members were impacted by the decision that you made. And it has come out today that you're educated, you have a master's degree. Some of these letters described you as smart and patient and kind and generous and thoughtful, but your actions on that date were none of those things. And your attorneys identified in the sentencing memo a few other similar cases where an elderly defendant had killed his or her spouse in some type of a mercy killing where that spouse was seriously ill. And the difference between those 3 cases that were identified and this one is the other victims. And that's what makes this case different to me. A lot of the letters that were sent in and even some of the testimony today talked about aid in dying laws and how Florida should have such a law. This is not the proper venue to make that argument. I am not a lawmaker. That is not my focus. That's an argument that needs to go to the Florida legislature and them only. Now, that's not to say that I'm unsympathetic to you, ma'am, because I can't fathom the difficulty of watching your husband's medical condition deteriorate to the point that he was in that constant kind of pain and wishing that he were dead. I can't understand that. I can't begin to understand how difficult it would have been for you to actually pull the trigger to assist your husband in ending his own life. I do believe that that is what you did. And so the punishment that I'm going to impose in this case is related to the other charges against you primarily. I've heard from the victims today, and I am highly persuaded by that testimony about the trauma that was inflicted on them. So, ma'am, I am going to adjudicate you guilty. You will be a convicted felon as a result of this incident. I'm going to sentence you to 366 days DOC, that's prison, and you will get credit for the 42 days that you've served. That'll be followed by 12 years of probation. The probationary terms are that you have to write letters of apology to the civilian victims and the 6 law enforcement victims that were identified in the indictment. And then this is an important part of the sentence as well. I want you to perform a minimal amount of community service hours per month for as long as you're physically able to do that. I want you to do 8 community service hours a month, so that's maybe 2 a week. And I don't care what you do, but I want you to realize, ma'am, that your life still continues to have value and you can contribute to society. You could even do work from home, like telephone or even via an internet connection. Again, I don't care what you do, but I want you to give back and I want you to enjoy the feeling of giving back to others as well. And then last but not least, there's going to be a mental health evaluation as a condition of probation, and you'll have to comply with whatever, if any, follow-up is recommended. It could just be take medication, but whatever the professional recommends is what you'll have to do. There are court costs of $770 plus 100 cost of prosecution and 100 cost of investigation to the police department, and you'll have to pay those off as a condition of your probation. So they're going to take you into custody today to begin serving that sentence. And again, you'll get credit for those 42 days that you've already served. Is there anything else that I need to address today?
Nothing from the state, Your Honor. Thank you so much, Your Honor. I appreciate it.
Okay. Thank you, folks.
Thank you.
Your Honor, the defendant is now at the bar. Can I have counsel identify themselves for the record, please, starting with the Commonwealth?
Good afternoon. Lisa Beatty for the Commonwealth. Good afternoon, Your Honor. Beth McLaughlin for the Commonwealth.
Good afternoon, Your Honor. Megan Monahan for the Commonwealth.
Good afternoon, Your Honor. Kevin Reddington on behalf of the defendant, who's before the court.
Okay. All right, good afternoon. So it was put over today for sentencing. I can tell you what I've reviewed. I want to make sure that I have everything. The Commonwealth filed a sentencing memo with some supporting documents, including some impact statements from the family of Katie McLean. I then received the defendant's sentencing memo, which included some letters of support, as well as an evaluation from Dr. Zeisel, and an attachment, the attachment being the sentencing guidelines. I then received the report from probation, the pre-sentencing report, which was very detailed. And then finally, this morning, I received the defendant's supplement to the sentencing memorandum, which cited other Superior Court cases. Is that everything?
Yes, Your Honor.
Okay. The Commonwealth move for sentencing at this time?
The Commonwealth moves for sentencing at this time.
Okay. And are you calling any members of the family to make impact statements?
So there are 3 members of the family who would like to read their victim impact statements.
Okay.
I will read, I'm sorry, there are 2 members who would like to read their impact statements, and I will read two.
All right.
Would you like to start with those?
I'd like to start. Why don't you read the first 2, and then the 2 family members who want to come up can take the witness stand, and they can give their impact statements.
Your Honor, the family had brought with them 2 sets of photographs that they wanted the court to be able to consider. If I could pass those to the
Yes.
clerk. All right, so first I will read Sophia's. And that is Exhibit 4. Dear Judge, every time I open my eyes, I am hit with the reality that my mother was taken from me. This fact crushes and plagues me on a daily basis. Thoughts of her flood my mind of how she lived her life. I think about how she'd joke about being Ariel from The Little Mermaid due to her red hair, blue eyes, laugh, amazing smile, Lily Pulitzer dresses, and life drama TV shows. Without fail, she would always complain about being cold no matter the weather. Now I dream of those days where she'd tell me to bring her a blanket. I dream about giving her a big hug that would last a lifetime. But instead of hugging her, I am hugging a tree that is in a cemetery, a tree that is not warm like my mom, but a hard, barky, cold tree. It's not the same. She will never be that tree. It will never be the same as hugging my mother. Even though I pretend that it is her, at the end of the day, it is still just a tree. I have lost time with my mother. My younger siblings have lost time with our mother. The world has lost time with my mother because of the actions he took that night. I am filled with regret from that night. I constantly think about what I could have done to change the outcome, or what I could have done or said that would have saved her. But I know that no matter what I did, I would not have been strong enough. She was not done living her life. She has been stolen from us by a monster that will never be as important as my mother. My mother was and is important. A part of me was forever lost when the monster stole my mother in the dark. This monster, who I don't consider a man or a person, but a failure and a waste of positive influence on the world, made the choice that night to hurt my mother, to rid the world of her, my support system. He will never understand what he took away from my family. He knew what he was doing when he ripped my mother's life away. He knew the consequences of his actions would result in her death. He put her in a cold, dark place. He took my mother from me, but I will use my mother as inspiration, as stepping stones for my future, and pass them on so that she can live forever in the words and stories I tell people. I will use my mother's wisdom and strength in my life so that she can live on. My younger siblings and I will continue our mother's legacy.
Thank you.
This is Sam Rocca's impact statement.
This is an exhibit as well?
This is Exhibit 6, I believe. Your Honor, my name is Sam Rocca. Katie is my mother. I had just turned 13 when my mom was killed. I knew I was special to her because I was the only boy and her baby. I wasn't sure what happened to my mom when this happened. I just knew she was dead and missing. The past 5 years have been the worst, loneliest years of my life. I lost my mom, my caretaker, the person who I depended upon for everything. As I've grown older, I realize more and more what I'm missing and how much I missed. I was just a kid when Harry killed my mom. As an adult, I realized I didn't know much about who my mom was. I didn't get the chance to have adult conversations with her and ask her opinion on life and what I should do. I stopped getting the chance to be a kid when she died. It's hard to have a childhood when you can't sleep, you're crying all the time, and just everything feels like a lot, and you have no mom to tell you, don't worry, it will be okay. My world has felt out of control since my mom died. I am left with a feeling of insecurity. I don't feel safe. I feel like I now need to create my own stability to keep myself safe and rely only on myself. I witnessed my mom crying in her home every day. I felt like a guest and was bullied by Harry, a grown man, on a daily basis. I will never forget that. I couldn't protect my mom from Harry. I think about that every day. Harry picked on anyone smaller and weaker than him. Now that I've grown, I've also realized the true devastation of what happened and what he did to my mother and who Harry is. Justice was not done. The portrayal of my mother was false, inaccurate, and having to witness it was devastating. I'll never know who I truly could have been had I had a mother to raise me and to guide me. I'm graduating in 2 weeks. My mom fought so hard for me for school, and she would have been happier than anybody to see me graduate, but she's not here for it. It's hard to be happy when the most important person is missing. I do know I want Harry to have the maximum sentence allowed, and I hope he stays in jail the remainder of his life.
Thank you.
Mary Grace at this time, please.
Hi, good afternoon. I'm very sorry for your loss.
Thank you. My name is Mary Grace Rocca. I am 21 years old, and Katie McLean is my mom. 5 years ago, I woke up in the middle of the night, looked down the stairs, and saw Harry Turk. I instantly knew something bad had happened. We made eye contact, and since then, I've been filled with a whole new level of fear I didn't know was quite possible. This fear didn't leave me after that night. I've been living the last 5 years of my life in a dark place, struggling to trust anyone, and feeling completely isolated. Losing my mom deeply affected the way I grew up and shaped my understanding of who I am. Without her guidance, I felt lost, which led me to cope in very destructive ways. Only now I am beginning to deal with the fear and grief he inflicted. Knowing how much my mom loved me and how that was taken away from me has broken me, and I have needed to learn to put myself back together without the person who was there for me. This was an intentional act of violence towards my mom, and Harry knew he would be leaving 3 kids alone without a mom.
Thank you so much.
Beth Mellison.
Good afternoon, ma'am.
Thank you.
Very sorry for your loss.
Thank you. My name is Beth Melanson, and Katie's my little sister. It'll be 5 years, May 15th, that my sister, Katie McLean, was brutally murdered in her home, a victim of domestic violence, just feet from her 3 sleeping children. Katie was killed just 4 days after Mother's Day in 2020, and here we are again, days after Mother's Day. As a healthcare professional, a critical care nurse with over 25 years experience, I honor people at life and in death, allowing my patients to live or die with dignity and respect while being honest, transparent, and truthful with their families. What I've been subjected to witness and listen to during this trial was far from the truth, lacking any respect for my sister, her 3 children, and allowed her to be re-victimized in death by Harry again. It has taken 5 years to this day to get to this, 5 years of daily grief, trauma, loss, and heartbreak of losing my best friend. 5 years of memories now without my sister and kids with no mother. 5 years ago, back in May of 2020, I got a call from the kids asking if I knew where Katie was. Then was informed Harry had been back from Florida. I knew if Harry was back, she was not missing. She was dead. The next day and a half, we waited. The police searched. The first night, it poured rain. It was freezing cold out, and I was so worried that she was outside hurt somewhere. We had no idea where she was. Around 11 o'clock, May 16th, I got a call from the state police saying they had found her, and she was dead in a pond. It was the most gut-wrenching pain I have ever felt in my life. I was shaking with disbelief, trauma, and pain. It was a blur for the first few months. The events and the people I now needed to take care of didn't allow me to grieve myself. I had to tell my mother her baby was dead, that Harry had killed her. I had to sit and tell Sophia, Grace, and Sam that Mom was found, but she had died. And we didn't know at that time what had happened. I will never forget that moment. I barely felt like my heart was beating. I was crying all the time while trying to take care of my 3 children, now Katie's 3 motherless children, and my own mother in hospice. I had to plan where and how to bury Katie with the 13, 15, and 17-year-old children. I had to go see my sister's body before the kids. After an autopsy and 2 days in a dirty pond, my beautiful sister did not look beautiful. I had to clean dirty black pond mud from under her nails. I had to put lipstick and jewelry on her. I had to fix her hair. I put her in a bright Lily Pulitzer dress because that's who she was. She was bright and she was happy. I tried to make her look like Mom for the last time that the kids would see her. Katie was not a vindictive devil, as stated by Harry minutes after he killed her and dumped her body in a pond with rocks to ensure nobody would find her. Katie was a daughter, she was an auntie, a sister, a friend, she was a caregiver, she was vibrant and full of life. She always had a smile, she was calm, she had more patience than anyone I know, and most importantly, Katie was a mother to her 3 children, Sophie, Gracie, and Sam. Everything she did in her life centered around her 3 babies. All of her life work was dedicated to caring for people who needed to be healed or taken care of. She was kind. She was gentle. She studied occupational therapy. She drove cancer patients to treatments who didn't have family. She did toy drives at Christmas. She volunteered at food pantries. She worked for years as a preschool teacher and always called the school her happy place with all the littles. She was a godmother to my children. She was a Eucharistic minister with the church. She was the room parent, the library mother, the Girl Scout troop leader, a Reiki practitioner, and she was my only relief in caring for our mother who was dying from Alzheimer's. Now, she's a victim of domestic violence and abuse. Her flaw was not that she was a vindictive devil, but that she was too forgiving of her perpetrator, thinking people could change and heal. My family and myself know about Harry's history. The bins lining the walls in her bedroom were packed and ready to leave the dictatorship within his home. There was no CPR performed on my sister. Any medical professional knows you don't move a body to a soft surface for CPR, especially a surgeon. Effective CPR needs to be done on a hard surface. Any medical professional also knows blood does not float up the back of your head when you're face down. It pools in a dependent position, and any medical professional also knows that a subdural hematoma is a key indicator of a violent, traumatic head injury, like repeatedly slamming someone's head off the floor. It is not a natural occurrence. The brutal assault and murder of my sister by Harry was by no means a momentary reaction or accident. The false claims of not remembering what happened, Harry dragged her body by her 3 children. Harry stopped. He saw one of the children, had seen him. He had that opportunity at that moment to stop, but instead, he kept going. He knew right away the perfect place to dump her body. He disposed of her body with no regard for her life, no remorse, and now he's not taking full responsibility. I've now needed to make room for 3 more children in my home. I stepped into the mom role, celebrated birthdays, graduations, proms, driver's licenses, as well as countless sleepless nights, endless tears, chronic fear, and PTSD. So many moments lost to her children forever, with a lifetime of lost moments and memories to come. I miss Katie every moment I am with her 3 children. I try to hug them like Mom would, trying to comfort them, give them advice like Mom would, knowing it's not the same. I'm not Katie. I'm not Mom. I pray to God that Harry stays in jail the remainder of his life, that he receives the maximum that can be awarded. There is no justice here because there is no truth here. This truly is the deed of a Dr. Jekyll and Mr. Hyde. I'll continue to protect and guide Katie's children as she would, and remember her like she was, full of love and light.
Thank you very much. Ms. Beatty?
Your Honor, as a preliminary matter, the Commonwealth would like to thank the court, the probation department, the court staff, and the police officers who are here today. Without all of those people, it wouldn't have been possible for the Commonwealth to bring this case to trial and for the defendant to receive a fair trial, and that's certainly a significant effort by everybody, and we appreciate that. We also appreciate the courtesy shown by the defendant and by defense counsel. This case was tried with efficiency, with professionalism, and with courtesy, and that's important as well. The lessons from the trial reinforce what we know about the dangers associated with trying to leave an abusive relationship. There are good reasons for no contact orders. We know that women who are victims of domestic violence struggle with obtaining safety, with obtaining resources for themselves and for their children. Housing and education are always high priority and difficult to obtain. You've heard from family and friends about Katie McClain's warmth, her talent as a healer, her love for her family, and particularly above all else, her love for her children. The sentence that the Commonwealth recommends is designed to address the harm that's inflicted by the defendant in this case, and the Commonwealth suggests is commensurate with the sentencing considerations as well as sentencing in other cases. I'm happy to respond to the court's questions about any of the other cases cited by defense counsel, but I would suggest that the majority of them are dissimilar and should not be considered by the court. Many of the defendant's letters that he submitted focused on his medical profession, and as stated in our sentencing memorandum, we don't think that that's the most significant consideration that this court should weigh in all of this. And so for all of those reasons, Your Honor, the Commonwealth urges you to sentence the defendant to 17 years in state prison. Thank you.
Okay, thank you. Mr. Reddington.
Thank you. Your Honor, I echo the Commonwealth's comments about the staff, the courthouse, Your Honor. This was a textbook, I think, trial that went in very fairly. All parties are certainly beholden to the court, as well as the court staff, to make sure that this is a very emotional case, but nevertheless was tried in a very fair, impartial fashion, for which we certainly appreciate. I know the jury put a lot of work into the case. They were very attentive, as Your Honor is well aware, and the jury has spoken. Whether or not the family of the deceased likes that, it's something that we cannot consider. The jury verdict. How many times do we say jury has spoken? We accept it. We don't agree with it, but we accept it, or we do agree with it. Jury put a lot of work into this case. They returned a verdict of manslaughter. We have things called sentencing guidelines. The reason that we have sentencing guidelines, and I know that you, whether you know it or not, your reputation is that you're, as we say, a guidelines judge. And that means that, as Your Honor, sentencing people, you do factor in, which you should, the sentencing guidelines. We don't, when I say we, I mean the defense bar and prosecute, we don't factor in emotion, we don't factor in facts of an individual case and try to get some type of vengeance or anything like that. We factor in, through the sentencing guidelines, a number of cases, studies, statistics that the Sentencing Guidelines Commission has put together to try, hopefully, and remove from the sentencing factors anger, revenge, excessive punishment, that type of thing, which is all too human. But the sentencing guidelines are something that a judge is able to look at and consider the factors that would guide those people to say, in this case, for example, that the guideline range would be 8 to 10 years. And that's based upon significant study, comparison of other cases, and their recommendation is something that I know is taken seriously by this court. I also understand that the family has a right under the statute to be heard, and they have a right to express their feelings, and nobody can understand the pain that must be suffered by family members when a person is taken from them at a young age, whether or not it's an accident, even worse if it's something like a crime of violence. I understand that. I certainly don't hold that against the people. I do feel that the emotion perhaps has taken sway. They seem to forget the 2 years that they lived together, that Harry provided for those kids. And I know that I had videos of many, many times that they were just out either in the pool, that they're laughing, they're having fun, they're downstairs in that basement room, and he stepped in, and as Your Honor knows, from motions in limine and things that were not allowed, and I'm not going to get into any of that, that there were a number of factors that he stepped in and tried to help out with Katie in taking care of those children. Suggest that the concept of being re-victimized, as set forth by the sister, I can understand the feeling, and I certainly don't criticize that. I'm sorry for any harm that I may have caused in the course of defending the case. I know that it must be difficult to sit there through a trial and listen to evidence, but nevertheless, that was evidence. When I come in here, I intended fully to get into a lot of factors that would be difficult factors to talk about. I sat with Harry, I spoke with Harry at length. He told me in no uncertain terms that he did not want any commentary whatsoever, disparaging or in any fashion saying anything adverse about Ms. McLean. And I respect that, and I'm taking that position. My request, as Your Honor knows, from the sentencing guideline range that I've requested is an 8 to 10. I would lose credibility, just as the family of the victim would like to see excess of the sentencing guidelines. My people, as it were, can't understand, well, why can't you ask for time served? He's been in jail for 5 years. And I try to explain to people, look, sentencing guidelines mean what that is. 8 to 10 is a reasonable request. I'm going to lose credibility with the court if I was to go in there and say, oh, no, give him credit, give him time served. No, I'm not going to do that. Wouldn't do that. I recommended guideline range, 8 to 10. Under the guidelines, as you're well aware, same thing in federal court, you can go over them. You can have a judgment where you feel that the factors of the case are such that an increase over the guideline sentencing range would be appropriate. The government has addressed that and said because he was married to her for the short period of time they were married, that's a position of trust and there's an abuse of trust, and also that the conduct after the homicide should drive an increase in the sentencing guidelines. And all I'm suggesting to the court is that the conduct after the homicide is exactly that. It's post-homicide conduct. Basically, fight or flight, taking advantage of the fear and trying to, obviously, as he testified, in a panic mode, cover up. But it's not indicative of the time of the incident and the killing. This was a killing that occurred as a result of hot blood, heat of passion. I suggest to the court that the letters that have been submitted to you show the respect that people have, and quite frankly, Your Honor knows that from his background. He has no record whatsoever. I'm not going to belabor the point that Dr. Zeisel has artfully presented to the court as far as his background, being raised behind, as we used to grow up and say, the Iron Curtain, his success in the medical field. Granted, that's wonderful, but it does not actually drive the sentence in this case. What drives the sentence in this case is sentencing the man so that it is, under the sentencing law, a sentence that is not greater than necessary to punish, to deter, and the other factors that were presented in the sentencing memorandum. So I'm asking that the court would consider the 8 to 10-year sentence to the state prison as being a fair and equitable and responsible sentence in this case. I spoke at length with Harry, and he would like, if Your Honor would permit, to exercise his right of allocution and be heard.
He has that right.
Thank you, Judge.
Your Honor. I'm sorry, Katie. Please forgive me for having reacted in such a way May 15, 2020, that it caused the end of your life. I'm thinking about you every day. I wish I could make it all unhappen. I have been struggling and continue to struggle with the events of that terrible night every single day, and I wish there would be existing a time machine I could go back and change the outcome of that night. But there isn't. So all I can say or do at this time is, I'm sorry, Katie. I'm so sorry. I know we will see each other in the afterlife. And I hope we can make peace with each other, and maybe you will be able to find a way to forgive me. I have been waiting for 5 years to be able to reach out to Katie's children, Sophia, Grace, Sam, as well as to Katie's family, to tell them that how I'm sorry I am about the tragic events during that night, May 14 to May 15, 2020, and my terrible role in Katie's death. Please accept my condolences and apologies, Sophia, Grace, and Sam, for having taken away your mom from you. I can't even imagine the loss and pain I have caused you by my actions. The same is true for the other family members of Katie. I'm truly sorry to have taken away your sister, your daughter, your aunt, or cousin. I know the loss of Katie has caused and continues to cause massive suffering and pain, and I will pray for you all in the hope that time will indeed heal wounds caused by the loss of Katie, and that it will help you to heal, and maybe even to approach the possibility to consider the forgiveness, mostly for your own sake. I also would like to apologize to my own family, particularly to my children and my friends. My terrible actions and the loss of Katie's life have caused them a huge heartache, pain, and suffering. My children and friends felt and continue to feel disappointed and ashamed of me and my role in the death of Katie McLean. I failed them as a father and a role model and complicated their lives very much. I'm very sorry for having you all let down in such an unimaginable way, and I promise to use the time in prison and afterwards to become a better father and man. Your Honor, you don't really know the man you are about to sentence. I'm guilty of a terrible thing. I'm responsible of the death of Kathleen McLean. I want you to know that I'm truly sorry about that. And while you consider punishing me appropriately for my actions during the night of May 14th to 15th in 2020, please also keep in mind that until that day, my life has been devoted to saving lives and not taking them. But that night, I miserably failed, and I'm very, very sorry. Thank you, Your Honor, for allowing me to address the court.
Mr. Reddington, anything else?
No, Your Honor, thank you.
Okay. All right. I'm going to step off for a couple minutes, so we'll be in recess.
All right. Follow court in session, please be seated.
All right. Let me just say that in determining what sentence to impose on Mr. Turk, I've taken into consideration a number of different factors. And certainly the starting point for this court are the disturbing facts that were found by the jury. The brutal attack and strangulation suffered by Katie McClain at the hands of Ingolf Turk. I can't imagine a human being facing her last moments on earth while being strangled by her husband. It's simply difficult to fathom. Moreover, while Mr. Turk is not charged with the improper disposal of human remains, the court notes that Ms. McClain's body was truly discarded like a bag of trash. The court acknowledges that this conduct is not to be considered as an aggravating factor as it occurred after the criminal act. However, the conduct is truly disturbing. I'm sure, let me just say to the family, that nothing that I can say can address the grief, anxiety, pain, anger that you feel on a daily basis, especially that you felt immediately after her death and disappearance, not knowing where she was or what happened to her. And then the additional grief of learning the circumstances of the recovery of her body and the anguish and grief that you'll suffer for the rest of your lives. As with any sentencing decision, I've carefully assessed the information made available to me in light of the sentencing goals of punishment, deterrence, protection of the public, and rehabilitation as reflected in the Massachusetts sentencing guidelines, which I've also reviewed. I've reviewed the Commonwealth Sentencing Memorandum, as I indicated, as well as the supporting documents. I've reviewed the Defendant's Sentencing Memorandum, the Supplementary Sentencing Memorandum, and supporting documents, including letters in support of the defendant. I've also considered the Probation Department's memorandum, as well as the very thoughtful and moving impact statements of the family members of Katie McClain. I've considered the facts of this case, along with the defendant's lack of a criminal record, his background and personal history, including but not limited to his many years of practice as a physician. I have considered the aggravating factors in this case, which include, but are not limited to, the fact that I do feel the defendant was in a position of trust, as well as the size and strength discrepancy between the defendant and Ms. McClain. I've also considered the mitigating factors, including the defendant's conduct and efforts to assist other detainees while he's been held pretrial. And let me just say that while there's no sentence that will satisfy all those concerned as a perfect representation of justice, this court must exercise its best judgment upon the evidence presented, the verdict returned, and all of the materials and arguments presented at this sentencing hearing as to the appropriate sentence to be imposed on Mr. Turk. Consequently, I fashioned a sentence that I believe will achieve these goals. Jim.
Mr. Turk, could you please stand?
What?
Stand up, please. Mr. Turk, the jury have returned a verdict of guilty of manslaughter on docket number 282CR138. The court sentenced you not less than 12, no more than 16 years at MCI Sousa Baranowski, and you stand committed pursuant to that sentence. You receive credit for 1,823 days served awaiting disposition. The victim witness fee is imposed. Thank you.
Thank you, Your Honor. Thank you, Mr. Clerk.
All rise.
Bob and Mike.
Well, I would agree with the last thing you said, which is I will look at this the way I need to, because Ms. Notley, this is a very difficult decision for me. The factors I have to consider include what's the appropriate punishment, what's necessary to protect society and the public, and what rehabilitation, and do you want rehabilitation, is possible. Every factor comes into play in this case. And what I have to decide, looking at each of those factors, is what happened. What I find frustrating about this case is that I'm the one that said bond. There was no OR bond, no EMU, and the prosecutor didn't want there to be any any restrictions on the bail pre-trial, and I've never seen a case with these charges without some restrictions on bail, and I never understood this case until I got the sentencing memos on Friday. Because no one ever shared any of the facts with me, or any of the damage, or anything that happened to the young man in this case. And now that I understand everything that happened, I do think that the most important factor that I need to look at is what's the proper punishment in this case. So let me say that there's several rehabilitation issues here, and I take them seriously. Dr. Bassman has sat in this witness stand, and he has testified, and he has been cross-examined by me. And in many sexual offense cases, he's providing a report. He's got a great program. So does ODRC. Same program. I am concerned about the need for rehabilitation and the desire to be rehabilitated. I don't know how sincere that is, because Ms. Nutley didn't start until after she pled guilty. And I have seen many defendants in this courtroom begin their rehabilitation, begin their treatment the day they get arrested, the day they talk to their attorney, long before it comes to sentencing. And I have a whole long track record of how they were doing, whether probation was a good idea. And in this case, I don't have that record, and I'm not sure what to do about the fact that Ms. Nutley, you waited until after you pled guilty. But more importantly, no one's really addressed the alcohol substance abuse issue that was in a court clinic report and in the facts. It's my understanding from the facts that I was given, it was the officer's statement, the text messages, the information that I have is that she was under the influence of alcohol, drunk. 2 bottles of wine at the Christmas party at the school on one of these days that the sexual battery occurred. And there's nothing about that. I don't hear any treatment for alcohol abuse. I don't hear any acknowledgement that that is part of the problem, or any want to be rehabilitated. And I think when you look at the court clinic's recommendation that there be treatment for both sex offense and alcohol abuse, I think that makes this even harder for a person to be successful on probation. So when I look at the factors, yes, the victim in this case was 17 years old, a student at the school, being counseled and supervised by an educator who he trusted, a person in power over him, a person who was supposed to be protecting him. And it's that relationship, your power over him, that gave you access to him, that gave you the opportunity to commit this crime at the school. And that is all the factors that make this a more serious case than normally a normal situation that constitutes sexual battery, all weigh in favor of a prison term. On the other hand, recidivism is another factor I have to consider. And you haven't committed a crime, you haven't been prosecuted for anything in your life, you have not been accused of this behavior in any other way, and I am going to ignore the statements and the materials that I have that there may be other situations or there may be other children who didn't want to come forward. I really cannot consider that. So I am just looking at the facts of this situation. But when I look at recidivism and a low risk that you have of reoffending, I worry about the alcohol abuse again. Because if that is what was causing the behavior and the terrible judgment, is it the depression? Is it your own trauma that you've had in your life that you know you can get treatment for? You know how to ask for help. This is part of your training, and your job is to ask for help for your students. You know how to ask for help for yourself. But you didn't do that. And if you didn't treat your trauma, you didn't treat your depression, your substance abuse, then I do worry that there could be this could happen again. So recidivism is an issue for me. But really, this final factor that I look at is remorse. And I was so looking forward to you speaking today, because I really wanted you to tell me that you were remorseful. And I don't want you to use those words. I don't care if you don't say the word apology. But, you know, what I was looking for was for you to say that you acknowledge the harm that you caused this young man and pretty much ruined the rest of his high school career. I didn't see it. I didn't hear it. I don't even know if you read the reports from his family, the letters from his family. But what I learned from reading that is that your behavior destroyed his confidence in himself, his education, his college career, his scholarships for sports, his relationships. He feels guilty. He feels shame, and he's the victim. I didn't hear or see anything that you acknowledge that. Ms. Nutley, you caused him the same trauma you suffered as a child of sex abuse. You knew what this would do to him. He shut out his family. He shut out his friends. That whole period of time between, I don't know when the relationship ended, honestly, I don't know any of the details about what happened after the last day in the indictment, December of 23, but it's not until October of 24. So 10 months, I see from the materials that you wanted him to keep your secret. And you encouraged him, and you paid him money, and you gave him favors, whatever you were doing. He was keeping your secret. That's what destroyed him. Because he hadn't had family, he didn't have friends, he had no one to talk to. And the way his father described the way his life changed, and didn't understand what was going on with him during that time, because he didn't know anything about the sexual abuse, and you were trying to make him keep this secret. He lived with his negative feelings. He felt guilt and shame. He was traumatized. He was not letting anyone help him because he was protecting you instead of you protecting him. Before the sexual offense, he had a mom and a dad and a sister and teachers who described him as happy and goofy and athletic and loving and hardworking, and a young man who had a great life ahead of him. And all of that is gone. He's not in treatment, from what I understand, which is very sad, because that's what he needs. He did not sign any school, so he doesn't have a lacrosse scholarship for college. He lost his spirituality. He became angry and cynical, and he distrusts people. I didn't hear any remorse for causing any of that, and that's what I was looking for. And I will say to this young man, because I just described you in a way that your family and friends and teachers described you, is that it is my hope that when this case is over and I sentence Ms. Nutley to what I hope is a just sentence, taking all these factors in, that you will be able to see how brave you have been to come forward and how courageous you have been to tell your story, first to your parents and then to the police. Because what you are doing is protecting other young men from being sexually abused by their teachers in many ways. Because you can show people you can be brave and you can speak out and you can tell the truth and your life will get better. You don't feel that way today, I'm sure, but hopefully in a few years, in a short time, you'll be able to seek the help and the treatment that you need, and that you'll be proud of yourself for doing this. So back to the sentencing factors, I left off at remorse, which I do not find genuine remorse in this case. And there's another factor I wanted to address that the detective put in his statement, and the prosecutor, Ms. Dieters, mentioned about what happened in this case now that we know all the facts. What are they thinking about what's the sentence going to be? Because I agree with Ms. Dieters. If they think they're just going to get a slap on the wrist, then why not? And I do consider that to an extent. And putting this all together and thinking this through, and I have been giving this a lot of thought, because if anybody knows me, they know that sentencing is the hardest thing I do on this bench. First, I want to address the family has asked for the maximum prison term, which is 5 years on count 1, 5 years on count 5, to be served consecutively. I do find I could make those consecutive findings, which means the possible maximum sentence is 10 years. And I considered that. And no one addressed the consecutive findings in any of their materials. The state's not asking for consecutive, but I looked it up and I thought about it and I've considered it. But when I balance everything, I do not think a 10-year prison term is the just term here. And you don't have to agree with me, but I just want you to know I did consider it seriously. And I did think about the officers, 18 months, because I thought that was an interesting number, and I appreciate today that you've adjusted that number. And I have looked at other cases. My staff looked up other cases. I think the median average was, the median and the average was 3 years on cases like this. And I did consider probation. Ms. Nutley, I think, talk to lawyers who practice in this courthouse. I love probation. I have a 90% success rate. Of the 90% of the people I've put on probation in the last 4 years have not gone to prison. I find that to be a success. But in this situation, I believe that the proper sentence is 3 years in prison on count 1, 3 years on count 5 to be served at the same time, for an aggregate sentence of 3 years in prison. The parole board must put you on a period of post-release control of 5 years after you get out of prison. And these sentences, and you are also subject to Tier 3 sex offender reporting restrictions, which I'll go over in just a moment. I will not require that you pay any fines, but you are required to pay court costs and a $30 reparations fund fee. I will put in my sentencing entry, Ms. Utley. I do take this very seriously, that there were comments that certainly you had suicidal thoughts at one point. You went to the Lindner Center. There was comments from something I read, worried that you might have suicidal ideations yourself. So I will put in the sentencing entry that ODRC will be required to evaluate you and the jail, if you'll start at the jail, for a suicide ideation, and provide all precautions necessary at the time that you're taken into custody. I want you to know, Ms. Nutley, I thought about this very seriously, and I do hope that you have hope and don't feel that this is the end of your life and career and relationship with your family. Because this is a punishment, and it will end, and you will come home, and you will get treatment, and you will have access to substance abuse and sexual offense treatment in prison and on post-release control. The post-release control period, which I said is a mandatory 5 years, as part of that, the ODRC can add additional conditions. In addition, you are not allowed to leave the state when you're on post-release control, and unless you have permission from your parole officer. The parole board can also impose any other post-release restrictions, sanctions, or financial sanctions that they choose. And if you are released from prison and placed on post-release control and you violate one of those conditions, they can send you back to prison for up to 9 months. And if you have multiple violations, they can send you back to prison for up to 50% of your stated prison term. If you commit a new felony while you're on post-release control, the parole board can send you back to prison for the remaining post-release control period, or 12 months, whichever is greater. And if you're sentenced on that new felony to prison, you'd have to finish your prison term on this case before beginning a prison term on any new case. Days of credit, you are able to earn those while you're in prison. You can earn up to 15% off your sentence. Next, I would like to go over the explanation of the duties of a register as a sex offender or a child victim offender. First of all, Ms. Nutley, you'll be a Tier 3 sex offender with notification requirements under the statute. I did not have a signed version of this form. Do you have a signed version for Ms. Nutley? Otherwise, she will need to sign it here in the courtroom.
I'll be submitted at the sentencing prepared then.
I'm going to fill this out and have her sign it when I'm done. She'll need to fill in her name and address and read and sign the form, but I'm going to go over it with her briefly. Ms. Ellie, you've been convicted of a sexually oriented offense or a child victim offense as defined by the law, and you are classified as a Tier 3 sex offender. You are required to register in person with the sheriff of the county in which you establish your residency after prison within 3 days of coming into the county. You must tell the sheriff of that county where you will be living, your education, where you'll be working, and if you have a change, you must make the sheriff aware of those changes within 3 days. You are required to provide the sheriff the temporary lodging information if your absence from the county will be for 7 days or more. After the date of the initial registration, you are required to periodically verify your residence address, employment, place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change your residence, address, place of employment, or education, you shall provide written notice of the change to the sheriff with whom you recently registered and to the sheriff in any county in which you intend to reside or work or go to school. At least 20 days prior to any change and no later than 3 days after a change of employment. Remember, employment includes volunteering. You are further advised, in accordance with federal law, you must report any international travel to the sheriff within 21 days prior to travel. Failure to do so can result in further criminal prosecution. You shall provide written notice within 3 days of any change in vehicle, email, internet, or telephone information that you have registered or you use, and you must report that to the sheriff where you registered. You are required to comply with all of these requirements as a Tier 3 offender in person every 90 days. It's my understanding when you come home, you will be living in Warren County. So this form will say that you are required to report to the sheriff in Hamilton County no later than 3 days upon your release. And the address will need to be added to the form for the sheriff registration in Warren County. So if you would fill that out, have her sign that, we'll make that part of the record today. A few more advisories for you, Ms. Nutley. This is a felony conviction. You are required to give a DNA sample to anyone authorized by state law. Failure to do so can result in further criminal punishment. You have the right to appeal my sentence. You have 30 days to file that appeal. If you cannot afford the documents or the costs, those will be waived. You are entitled to an attorney on appeal. If you cannot afford one, I'll appoint one for you at no cost to you. You can tell me now if you'd like me to appoint appellate counsel, or let me know within the next 30 days, or let your attorney know.
I'll speak with her about that, Judge. I'll let the court know.
Okay. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Yeah.
Ms. Nutley prepared to be taken in custody?
Yes, sir.
She needs to read and sign that form, and then you can take her into custody. Probably. You can come over. Oh, I thought you should move over here, because she's getting faster. Or you can back up. Copy.
Members of society expect the guilty to be held accountable for their actions and rely on the criminal justice system for some measure of closure. No sentence or comments by the court will lessen the profound sense of loss caused by your actions. But you, Mr. Morales, will be held accountable and sentenced accordingly. Mr. Morales, please rise. Upon the court's considerations as outlined on the record, the following sentence is hereby imposed. As to the finding of guilty of the crime of murder of Christine Holloway, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 60 years to serve, which in accordance with our statutes is defined as life. As to the finding of the crime of tampering with physical evidence, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 5 years to serve, to run consecutive to the sentence on the murder for a total effective sentence of 65 years to serve. At this point in time, I'm going to note your right to appeal. I'm also going to note that Connecticut General Statutes 1898E does not render you eligible for risk reduction credits on the murder, that 60-year sentence imposed. You may be eligible, however, pursuant to our statutes, if applicable, to earn risk reduction credit on the sentence imposed on tampering with physical evidence. Total effective sentence, 65 years. The court is going to waive any costs and fees for good cause in view of the lengthy incarceration. You do have a right, sir, to seek sentence review and modification as provided by way of statute. As applicable, Madam Clerk will outline the documents she's providing you, which will also include a pardon brochure. Madam Clerk, would you please provide defense counsel and defendant with a copy of the documents, and please state on the record what documents you are providing.
Your Honor, we have executed the documents you're referring to and forwarded those to Madam Clerk for filing after the conclusion of today's hearing.
Okay, so just let the record reflect that the defendant is in receipt of his right to appeal, his conviction, his right to sentence review modification, as well as a pardons eligibility brochure. Counsel, is my understanding that there is property being held in this matter?
Your Honor, with the court's permission, we'd ask that all seized property be held pending the appeal.
As well as the fact, Your Honor, that there is an open investigation, so all property that was currently entered into evidence asks that it be maintained by the clerk's office for appellate purposes as well as additional investigatory purposes.
All right, the court will order the property be held for appeal purposes. The court wants to thank counsel for your professionalism in delivering your case and presenting your case to the jury during the trial, and your arguments to the court of the sentencing proceeding, as well as your courtesies to one another. And I'd like to also thank the members of our audience for maintaining courtroom decorum during the trial and the sentencing proceeding. I appreciate that. Thank you. At this point in time, if there's nothing else.
There is two additional matters, Your Honor. I'm not sure if I know that there are costs. I'm not sure if the court entered orders with regard to that.
I did. Costs and fees are waived.
With regard to, there is a second file. It has been docketed today at my request. I will identify it as State of Connecticut versus Jose Morales. It is AAN CR 19-022-552T. This is a matter, 2 counts of criminal possession of an electronic defense weapon. This is a matter, it was an arrest effectuated by the New Haven Police Department during the course of the investigation. In this case, it was a matter that was pending in the New Haven Judicial District, and due to the fact that it was expected that this case was going to take a while, I agreed to accept jurisdiction of that case, and at this time, State is entering a nollie to both counts of those information based upon the sentence imposed by this court in the economy and administration of justice.
All right, so relative to that particular case, the court will go ahead and note the nollie. I am assuming due to the nature of the charges, there's also property in that case.
There is property. I would ask that those be destroyed.
No issue with that.
All right, court will go ahead and order the destruction of the property held in the case that was nollied. Is there anything else to be addressed by the court?
Not from us, Your Honor.
All right, thank you.
Thank you.
State?
I'm good, Your Honor. Thank you.
Court stands adjourned. Thank you. The sentence imposed will reflect the court's findings relative to solely those charges. I also want it noted for the record that multiple members here in support of the decedent have come into court today with T-shirts that depict the face of Christine Holloway. That is your right to do so. I did not preclude you from doing so, but I will note from the record that the court was not unduly influenced by that display on your apparel. Sentencing in a case such as this is a monumental task for any judge. The court must consider the goals of sentencing, which include, among other things, the court's obligation to impose a fair and just sentence, which enhances the public safety, holds the offender accountable, affects general deterrence in order to reduce criminal activity and promote rehabilitation. In doing so, the court also considers the seriousness of each offense and the facts established at trial. I'm not going to restate all the testimony and evidence that was presented during the trial of this case, and I do wish to spare the family members of any additional pain. However, I must comment briefly on the evidence that the jury heard for the benefit of any future proceedings. It was established beyond a reasonable doubt, our highest burden of proof, that the defendant specifically intended to kill and did in fact cause the death of Christine Holloway. It was further established beyond a reasonable doubt that the defendant intentionally tampered with physical evidence relating to the homicide of Christine Holloway. The evidence presented to the jury established that Christine was only 43 years old when her life was needlessly and violently taken from her at the hands of the defendant. This was not accidental, as the jury found, but rather intentional. It was a gruesome, intentional physical attack on Christine. The evidence that the jury heard included multiple blunt force injuries to Christine's head and neck, including skull fractures with a minimum of 8 blunt force impacts, leaving behind a horrific crime scene full of blood and brain matter and the lifeless body of a young mother, sister, daughter, co-worker, and friend. In lieu of calling the police or contacting anyone for help, the evidence presented to the jury indicated that the defendant stayed at the apartment, attempted to clean the bloody mess on the floor, discarded brain matter in a sink, and collected and discarded other evidence with blood on them at a donation box. In fact, bags of physical evidence, including children's toys splattered with blood, adult clothing, and other objects, all while leaving the lifeless body of Christine Holloway in a bathtub back at the apartment. Christine's body was left in a bathroom bathtub with candles lit and a skylight open. The defendant fled the scene. The defendant did take the stand in his own defense, telling the jury of drug use and unknown intruders, and how one of those intruders struck Christine multiple times with a crowbar and one took his daughter and ran out the door. A jury of 12 rejected his account of what happened to Christine, and the jury's findings are supported by the evidence. To the victim's family members and friends, thank you for your patience with this process, which admittedly has been extraordinarily long to bring this case to conclusion, and most certainly very difficult to endure. Although a conviction and sentence cannot bring back your loved one, I hope that it will provide some closure as to the investigation into Christine's death and open a path to the healing process, which I'm sure will be a lifelong process for many, if not all of you. I have heard through your statements and your letters to the court, which have provided a sense of life to Christine here in the courtroom. I understand how you feel today, how you've felt for many years, and you've given the court some indication of the type of person that Christine was. The impact of this crime, of the defendant's conduct within our society, is profound. A vicious crime such as this severely impacts the overall feeling and safety in our society. Society should not have to fear such careless indifference to human life. It makes you question who really lives next door to you. Christine had the right to be safe in her relationship with her young daughter's father, safe in her own home. This was a cruel, intentional, senseless, violent act. The defendant must be deterred from ever committing such an act. Violent, senseless acts from happening in our society. The facts of this case, along with your criminal history, Mr. Morales, leave this court to believe that you have no regard for the rule of law and a callous disregard for human life. Your record clearly establishes that prison sentences, probation, and special parole do not dissuade you from committing future crime. Any consideration to be given to the aspect of rehabilitation in this case pales in comparison to the severity of these crimes. Mr. Morales, you are a dangerous person, a significant threat to society, and you need to be removed from the community for a substantial period of time. The victim's family, as well as the members.
Your Honor, Ms. Zimmercheck mentioned a case in her argument, Stephen Morgan, where the defendant was given time served. That actually happens to have been my case, and the two cases are diametrically opposed to each other. Mr. Morgan was not present during the murder, did not help dispose of the victim's body in that case, came forward immediately when questioned by police, and cooperated throughout the entire way. He also pleaded guilty only to accessory after the fact and did not, as Dontel has done, plead guilty to criminal conspiracy to commit murder. So I just want to make sure that it's clear that that is not an appropriate comparison with the case in front of Your Honor.
Ms. Walter, let me ask you this. It got brought up in the defense's presentation about bond. Am I correct that he was given a bond at one point but violated it?
Yes, Your Honor. Both defendants were given bonds. They both violated it by having continued contact with each other. They were both violated, and then Ms. Jackson was released, violated again. It was sort of a revolving door. She was given an opportunity for home detention again, but continued to violate it. I believe there was one other bond hearing for Mr. Dontel, and that was denied. But he has been in since that first violation.
And I'm also correct that there were initially talked to law enforcement, and then there was a proffer?
Yes, Your Honor, there was a proffer, and Mr. Dontel violated the terms of that proffer, so that proffer never went forward.
Okay. Mrs. Zimmercheck, anything else from the defense?
Nothing further. Well, just a very brief follow-up, Your Honor. Yes, he had 3 detention hearings after that. They were all denied. The end result was the same. And Your Honor, he did the proper and the testimony was all done prior to my involvement in the case, Your Honor. Obviously, when we were able to secure that protection for his family with the bond conditions and zones against his family and her and the children, Your Honor, he did sit down and I think fully cooperate with them and testified to those exact same details at the trial.
All right.
Thank you.
Okay. Mr. Dontel, your attorney has done a good presentation and quite frankly, I believe has done a remarkable job to get you where you are today. She's correct that my law clerk did go in and view your testimony in Megan Jackson's trial, but I also went back and viewed your testimony as well. Your testimony did differ in what you admitted to when you pled guilty to the charges you're here for today. My concern is simply this. I understand that you're remorseful. You're here today to take ownership over what you've done. However, by my math, it took about 1,500 days for that to happen. You said in your testimony in Ms. Jackson's trial that you were scared of Ms. Jackson. I don't know what you were scared of once she got incarcerated, though. She absolutely couldn't hurt your family when she was incarcerated. And you still decided that you wanted to withhold the truth. And then you testified or proffered again with the state and again gave them different information. The truth of the matter in this, according to your own testimony, is that you were present when Mr. Greg Rice was gunned down and that you helped dispose of that body. You, a person who disposes of bodies as your job. And yet it took you 1,500 days before you gave this family some solace in knowing what happened to their dad. I saw in your testimony where you hoped that your testimony would give you a lesser sentence. And I'll tell you that based on your testimony, the fact that you pled to an accessory and a co-conspirator is your lesser sentence. You very easily could be right where Ms. Jackson is, doing life in prison. I will give you the credit for the time that you have served. You're entitled to that by statute. But as to the accessory after the fact, it's a sentence of this court that you be committed to the State Department of Corrections for a period of 15 years. And as for the conspiracy, it's a sentence of this court that you be sentenced to the maximum again of 5 years, and those are to run consecutive. Mr. Dontel, I understand that you're here and want to give the closure to the Rice family, and I hope that this does that. And I hope that ultimately, when you get out, that you will remember what you've done to your own family and what you've done to the Rice family. But that's the sentence of this court. Thank you. Ms. Walker, do we have anything else?
No, just your regular trial roster.
All right, thank you. We'll be at ease.
And if that trial resolves or ends and you or Judge Nettles
States present, defendant is present with counsel. Ladies and gentlemen of the jury, have you reached a verdict? Okay, and are you the foreperson? Yes. If you would hand the verdict form to our court deputy, I'm going to review it, make sure it's been filled out completely. Believed to be in proper order, and I'll have Madam Clerk publish the verdict. Ms. Agee, please rise to accept the jury's verdict.
In the Circuit Court for Escambia County, Florida, State of Florida Plaintiff versus Sheila Annette Agee, Defendant, Clerk number 1723 CF 003379B, Division A, Verdict. We, the jury, find as follows as to the count charged in the indictment. Count 1. Guilty of principal to first-degree murder as charged. So say we all, this 6th day of August, 2025, Juror Carpenter, foreperson.
Would either party like the jury polled?
Yes, Your
Honor. Okay. Madam Clerk's going to poll you. She's going to ask you a question. If you'll just respond to her question.
Juror Carpenter, is this your individual verdict as well as the verdict of the jury as a whole?
Yes.
Juror Quadrosi, is this your individual verdict?
Yes.
Juror Edwards, is this your individual verdict?
Yes.
Juror Potter, is this your individual verdict?
Yes.
Juror Ram, is this your individual verdict?
Yes, ma'am.
Juror Radat, is this your individual verdict?
Yes.
Juror Progarski, is this your individual verdict? Yes. Juror Murray, is this your individual verdict?
Yes.
Juror Dunlap, is this your individual verdict?
Yes.
Juror Olson, is this your individual verdict?
Yes.
Juror Blake, is this your individual verdict?
Yes.
And Juror Alden Coe, is this your individual verdict?
Yes.
Thank you. Mr. Ackerman, if you, Ms. Agee, would like to have a seat, I'm going to read the final instruction. This is the last instruction from our Supreme Court before we release you for the evening. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. I do want to take this opportunity to thank you for your service on Monday, yesterday, and again today. You gave 3 days of your time to help us resolve this case, and we certainly appreciate the time and consideration you've given to this case and your willingness to serve. I am going to reintroduce the attorneys. We have Ms. Bridget Myers-Jensen. She's the Chief Assistant State Attorney here in the First Judicial Circuit, and Mr. Alvin Trey Myers, and he is the Deputy Chief Assistant State Attorney here in the First Judicial Circuit for the state of Florida, and Mr. David Ackerman, who's in private practice here in Pensacola. And I always like to reintroduce them in case you wish to reach out to them. They won't reach out to you, but if you'd like to, I know when I was trying cases, I did on a few occasions have jurors contact me, and it was helpful to understand, what the discussions were in the jury room. But again, that's up to you. You're not required to do that in any way, and you can find their contact information online. And again, this will count as your jury service for the year. And we again appreciate your hard work and time and consideration this week. So on behalf of myself, the Assistant State Attorney, Defense Attorney, Defendant, we thank you. You are now free to go, and our court deputy will get you checked out. And have a nice rest of your week. Thank you.
Your Honor, based on the jury's verdict, we should proceed to sentencing today. Ms. Brooklyn's mother is here, and she would like to speak before the court in her sentencing. You want to come forward this way? Yes, ma'am. Ma'am, if you'll raise your right hand for me.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, nothing but the truth?
I do.
Okay, if you'll just state your name for me, ma'am.
Cornelia Sims.
You have something to read for the judge?
I do.
Okay, please go ahead.
Webster's dictionary defines a mother as a woman who has given birth to a child, provided an egg for a child, or who has legally adopted a child. My definition of a mother is a selfish, loving human who often sacrifices many of her own wants and needs for for those needs of her children. A mother makes sure that her children are equipped with knowledge, skills, and the abilities to make it as a competent human being. It has been 1 year, 11 months, and 25 days since my daughter, Brooklyn Taylor Dior Sims, was tragically taken from me. I miss my daughter. Casey lost her mama. Casey lost her daddy. Casey lost her other grandmother. When I say my granddaughter does not understand, and I don't know if she ever will, what happened on August the 11th, 2023. When I say this, I'll never be the same. Try to go on for Casey's sake, but I'll never be the same. I want to thank you, Trey, Ms. Bridget. Thank the jurors. That today, justice for Brooklyn Taylor Sims has been served.
Can I ask you one more question?
Yes.
How's Casey doing now?
She's thriving. She's getting big. At the time of the incident, Casey was 15 months. October, Casey will turn 4. She's just like Brooklyn. When I say identical, she looks like her from head to toe. She's her mom.
Thank you.
You're welcome.
Your Honor,
Anybody else that wanted to be heard?
I don't believe so, Your Honor. Based on the jury's verdict, though, there's only one lawful sentence, Your Honor, and that's adjudication of guilt, life in state prison without the possibility of parole. I believe the court costs are $518, and that's all the state has, Your Honor.
I believe her credit was 722 days.
Judge, may I client would like to say something.
Yes, sir. Just 1 second.
Your Honor, I would like to say that Ms. Sims is 100% correct. I failed as a mother. I failed as a friend. And I failed as a grandmother. And it was something Brooklyn didn't deserve. There's no way I can express my sorrow to you. And I'm sorry, I don't ask for forgiveness. I don't ask for forgiveness. And I don't ask for forgiveness when you need a PP. But I want to let you know you are a great mother. You are a great mother. You are a great grandmother. And you were a great friend. And I let you down. And I apologize from the bottom of my heart for letting you down. And I hope you strive. And I hope Casey strives. And TT, I hope you and Ada strive. And I'm sorry from the bottom of my heart. And thank you, Ms. Jensen, and thank you, Mr. Trey. And thank you, Mr. David. And I am so sorry to my family. I love y'all. And Your Honor, I apologize to you as well. Thank you.
Thank you, Ms. Agee. Mr. Ackerman, anything else from you, sir?
I'm sorry,
I said, was there anything else from you?
no, Your Honor.
Okay.
Already time.
Based on the jury's verdict finding you guilty as charged of principal to first-degree murder, I will adjudicate you guilty of that charge, sentence you to life in the Florida Department of Corrections without the possibility of parole. I believe she has credit for 722 days. Any objection to that amount of credit? And she'll be given that credit. I'll impose $518 in court cost. Madam Clerk, there's no other required cost, correct? All right. And This is the judgment and sentence of the court. You have 30 days to appeal. If you cannot afford a lawyer, one will be appointed to represent you. And all financial obligations will be reduced to judgment lien. I'll remain to observe Ms. Agee get fingerprinted, but otherwise, court is adjourned. Yeah, maybe go check and make sure. I'm fine. If y'all need to step back with me, you can.
See you tomorrow, Judge.
I'll see you in the morning. Okay.
All right. If the defense would please rise, and if Madam Clerk could please publish the verdicts.
We, the jury, find as follows as to Shelby Neely in this case. As to count one, we, the jury, unanimously find the state proved beyond a reasonable doubt that Shelby Neely was previously or contemporaneously convicted of another capital felony or a felony involving the use of violence to another person. Yes, 12. We, the jury, unanimously find the state proved beyond a reasonable doubt that the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Yes, 12. We, the jury, unanimously find the state proved beyond a reasonable doubt that the first-degree murder was committed in cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes, 12. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Shelby Neely should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 11-1 that Shelby Neely should be sentenced to death. As to count two, we, the jury, unanimously find the state proved beyond a reasonable doubt that Shelby Neely was previously or contemporaneously convicted of another capital felony or a felony involving the use of violence to another person. Yes, 12. We, the jury, unanimously find the state proved beyond a reasonable doubt that the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Yes, 12. We, the jury, unanimously find the state proved beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes, 12. We, the jury, unanimously find the state has proved beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes, 12. We, the jury, have unanimously found that the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Shelby Neely should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 11-1 that Shelby Neely should be sentenced to death. As to count three, we, the jury, unanimously find the state have proved beyond a reasonable doubt that Shelby Neely was previously or contemporaneously convicted of another capital felony or a felony involving the use of violence to another person. Yes, 12. We, the jury, unanimously find that the state has proved beyond a reasonable doubt that the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Yes, 12. We, the jury, unanimously find the state proved beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes, 12. We, the jury, unanimously find the state proved beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Shelby Neely should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 11-1 that Shelby Neely should be sentenced to death. Dated this 25th of July, 2025, in Pinellas County, Florida, Trina Fredrickson, foreperson of the jury.
All right. The defense may be seated. All right, Ms. Fredrickson, let me just ask you one question here. For all the aggravating factors, you checked yes, and then you put 12. But for the very last one, you just checked yes, which is really all you had to do. But that was unanimous as well, all 12. Is that correct? Yes. All right. All right, so what I'm going to do now is what's called polling the jury. I'm just going to ask you if, in fact, is what the clerk just read accurate as far as what the jury decided on all of these verdicts, okay? So, do you agree that the decisions as read by the clerk accurately reflects what the jury decided?
Yes, Your Honor.
Thank you. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Very good. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Very good. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Very good. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Very good. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Very good. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Very good. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Very good. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Okay. And do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Okay. All right. Did I skip somebody?
The last one.
Okay. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Okay. All right. Well, it's been a long, grueling couple of weeks for you and for everybody else, and obviously this is a very difficult process for you and everybody else. This is the most difficult decision that you really have to make in the law, and we greatly appreciate your participation. It seemed like you were really paying attention to everything. You really took this thing seriously, as you should. It's a very serious issue, and there were long days. They seemed to shorten up a little bit at the end of this week, but there were some long, long days. And on behalf of everyone involved in the case, I'd like to thank you very much for your jury service.